So the Department of Justice wants more money. Maybe it's because they got more problems. They're seeking to increase the fees for ammunition purchases in California. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, what was originally an infringement on our Second Amendment rights has taken a hike to another level, seeing the ammunition purchasing fees go from $1 to $5 in this DOJ proposal. Here to walk us through it, he is the author of that book that we shouldn't need but everybody wants. That's right, that is the California Gun Laws book. He's an attorney at Michelle & Associates. That is Matt Cabero. Matt, thanks for being with us today.
Thank you again for having me.
Absolutely. And guys, before we get in this today, please be sure to like, share, and subscribe to these videos. We're trying to bring you this information as quickly as we can as a complete package so that you can understand what we need to do going forward to advocate for our rights. So hit that like button. Go ahead and share and subscribe to these videos. It really helps get it out to as many people as possible. So Matt, I guess before we look at what we have in front of us, can you give us a quick review? Where does this $1 ammunition purchasing fee actually come from? And where is it going with this $5 thing? So can we just sort of have the history of where this came from in the first place?
Sure. So obviously back in 2016, Gavin Newsom at the time proposed a voter initiative that was all-encompassing for the most part regarding firearms in California, including ammunition. And it included a provision that would create one of the first of its kinds background check requirements in the United States for the purchase of ammunition. There was, of course, a competing Senate bill that both were ultimately adopted and resulted in the system that we have here today. And so basically, for individuals that are looking to purchase ammunition just to have at their home for self-defense or to go target shooting at the target range one day, that kind of thing, the general requirement is that they have to undergo a background check. And there's different ways that you can accomplish that. The most common method is to do what they call a standard ammunition eligibility check, which basically what it does is it checks the California Department of Justice's database called the Automated Firearms System, which is the record of all of the DROS transactions that have taken place here in the state of California. And it will cross-reference that database with another database called the Armed Prohibited Person System. And so basically what DOJ is doing is they're wanting to check first that you actually purchased the gun in California. It doesn't have to be of the same caliber or anything like that, just that you underwent a background check at some point, but you're also not currently listed in the Armed Prohibited Person System, meaning that you're prohibited from owning or possessing firearms. And assuming both of those two come together and you've purchased a gun and you're not listed in that system, you can purchase ammunition. But the fee for doing that check is currently a $1 fee. And that's what the DOJ adopted pursuant to regulations implementing Proposition 63, and the relevant Senate bill that was adopted back in 2016.
And that proposition, had a lot of other things in it as well. That's where the Duncan v. Bonta lawsuit came from. That's where the Rhodey v. Bonta came from. We've challenged a lot within that proposition in that of itself. But let's go ahead and see, Jacob, if you can pull this up onto the screen. This is the proposal from the Department of Justice so we can see exactly where they're coming from. It says this: the department's regulations benefit public safety by creating a process which will ensure an individual prohibited by state law from possessing ammunition will be unable to purchase or transfer ammunition. Raising the fee from a COE verification check from $1 to $5 will help cover the department's reasonable regulatory and enforcement costs for operating the ammunition authorization program. So, Matt, I got to ask, it seems like what they're saying is the $1 not working. So how did they come to the $1 for the fee originally, and what about it isn't working to where they need to increase it to $5 now?
Well, so I think initially when DOJ first adopted their regulations, they were trying to intentionally make the system as minimal impact as possible because they knew that it was going to be subject to legal challenges, which of course we filed the Rody case challenging it just in just that fashion. But initially, this whole fee came about through some fancy accounting that the California Department of Justice did when it first implemented these regulations. And so, as part of implementing the background check fee, DOJ was given a loan of $25 million from the legislature to develop and implement the system. Now, I can go into, I could ad nauseum go into detail why I think the $25 million was wholly unnecessary as far as what we've actually seen, how it's been used and implemented. But that loan is now effectively coming due. And so when DOJ first adopted their regulations setting the fee at $1, they anticipated that there would be approximately 13 million transactions utilizing the standard ammunition eligibility check, the $1 check option, every year. And this proposal makes clear that they have now revised that number to be approximately 1.3 or so million transactions per calendar year. And so it's basically 10 times less than what they anticipated. And so the revenue that they anticipated to be generated by the system is substantially less than what they actually were anticipating initially. And so now that the loan that they initially obtained when they first implemented the system is starting to come due, and the DOJ is starting to have to repay that, the system, if it were to continue in this current form, is effectively insolvent. It's losing money every year. And so that is why I think the DOJ here is basically in a panic trying to raise the fee to account for their shortcomings as far as their estimations back when they first adopted the fee.
It's almost like the conservatives' guide to socialism. If you want to draw it a comparison to taxes, you raise taxes, people leave because they don't want to pay those taxes, which only forces the government to raise taxes on its existing citizens even more. Is that line of logic the same here? They anticipated 13 million transactions. They got one, which is forcing them to raise the prices here, which is going to inevitably have a result of even less transactions, which would then force them to raise it even more in order to sustain this model that they have. Am I incorrect in that logic?
No, I think you're absolutely correct. And I think it raises substantially more questions where you're effectively raising the fee to engage in these types of transactions. Basic economics would suggest that means you're also going to get even less transactions, out the door the following year, should you raise the fee in this fashion. And so I think that this is starting to show just how either you could say it's poorly managed or poorly thought out or just simply doesn't work in the long run, that this system, if it's going to continue the way it is, it's ultimately going to be defunct simply because it can't be paid for anymore. And so if you have people that are starting to having to get forced to pay $5 just to buy what should be a $5-10 box of ammunition, maybe the people aren't going to be actually buying that anymore. Maybe that's the intent. That's what they're ultimately hoping for. But at the end of the day, if the system becomes insolvent the way that these numbers are suggesting, it's just not going to work, period.
Well, it shouldn't surprise anyone that the California legislature is fiscally irresponsible. We're in a budget crisis right now, and unfortunately, time and time again, the only victim of these catastrophes are the citizens. In this specific case, it would be the firearms community. Let's talk really quick, though, about litigation or potential litigation. Jacob, if you could bring the proposal back up onto the screen. I wanted to get your take on this, Matt. It's under the comparable federal regulations section here. It's just one sentence. Literally says there are no existing federal regulations or statutes comparable to these proposed regulations. I got to ask, Matt, in an age where the Supreme Court passed down Bruin, which forces the court to look at these lawsuits through the lens of history, text, and tradition, is the Department of Justice writing our lawsuits for us by telling us that there are no federal regulations like this one?
Well, it is rare to see, the truth be told, so to speak, by government agencies, but it is the truth that California is unique in that it has this system that they've adopted for the purposes of conducting background checks on ammunition sales. And so obviously we filed the Rhodey case once the ammunition law was enacted. And we were successful, at least initially, in obtaining an injunction. Now, of course, that was stayed, and the case is still working its way through the courts. But now that we have the Bruin case, even though the Rhodey case is still stayed pending the results of the magazine case, Duncan, I would wholly expect that this is going to be a significant issue in the Rhodey case with the test that's been adopted by Bruin, which looks at, whether or not there are comparable laws or regulations that were in effect at the time of the founding of the United States or the ratification of the Constitution. And so clearly, if you have a statement by the government that makes clear that this has never been used or adopted before until, very recently within the past 10 years, that makes the law immediately suspect under the Bruin test that we now have, which was, of course, adopted following the initial filing of the case. And so I remain hopeful that at the end of the day, we'll be able to get the ammunition law struck down, at the very least on the new test that's been set forth in Bruin. But there's still a lot of work that has to be done. And of course, the case, like I said, is still stayed pending the results in the Duncan case. And so we'll see where that takes us.
Yeah, certainly optimistic if you want to throw this in the basket of Freudian slips, if that's what it ends up being. But you kind of maybe answered something that I was curious about, but I'll ask it anyways just to be sure. This isn't necessarily if it does become a regulation. I understand it's going through the process of a proposal right now. It wouldn't require any new litigation. I know this is something that is argued within the Rhodey case that's existed in the courts for a while now. Is this just a supplement to that, or would it require a new lawsuit?
So the regulation itself that's being proposed is a very simple, straightforward change. It's simply increasing the cost from $1 to $5. And so the additional documents and the fiscal statements and everything else that get associated with that, we would potentially be able to introduce as further evidence in the case. But generally speaking, you're correct in the sense that we should be able to utilize whatever changes they decide to make here, whether it be through the regulations or otherwise, in moving forward with the Rhodey case. And so it wouldn't require, for example, a new lawsuit or something like that. But nevertheless, these are proposed regulations. And so there is a comment period that will be open. And we will encourage, of course, everyone that can and is willing to submit comments on the proposal. I'm sure we'll be putting out more information after we've gone through some of the more detailed documents that they've included with their proposal here. But I think it's important for members of the public to know that if you are able to, you can and should submit your comments on the proposal increasing the fee to the DOJ and the Office of Administrative Law. And that deadline will be October 8th of 2024 this year at 5 p.m. So we still have some time for people to submit comments. We'll be submitting our own comment letter on it, of course. And so it's, of course, just for any and everyone that can to participate in the rulemaking process to make sure that your voices are heard.
Yeah, so Jacob, if you could bring that up onto the screen, it is our last slide from this proposal. It says, any interested person or their authorized representatives may submit written comments relevant to the proposed regulatory action. The written comment period closes on October 8th, 2024 at 5 p.m. Only written comments received by that time will be considered, and there is the info. We can leave it up there a little bit more just in case you want to take a closer look at that. So, Matt, we saw emergency regulations proposed toward the beginning of this year on the SB2 regulations for CCW instructors. Is this the same process that we went through with that as far as the way people can submit their written comments?
So it's a little different in that this is the actual traditional rulemaking process. They're doing it the way that most regulations can and should be adopted, which is to give the public a 45-day public comment period, at which point the DOJ, upon receiving those comments, will have to issue responses to any and all comments that it receives, and then issue a sort of final rulemaking proposal following any revisions that it decides to make or changes that it decides to make, or any of its responses to those comments. And so this is the California's more, I should say, robust rulemaking process in that regard, and that it's unlike the emergency proposal system, which basically gives many agencies that enact regulations pursuant to that process sort of a much larger deference, and doesn't really care about responding to comments in the way that the traditional rulemaking process is concerned. So it's good that they're doing it this way as opposed to that way, for sure. But nevertheless, it's still something that it's very important that individuals can and should submit their comments on the proposal.
Well, certainly that is the issue. That is the path to making sure that that issue doesn't become a reality. So I guess what are your final thoughts on this, Matt, going forward? You got the 45-day comment period for people. Do you see this ending up becoming a regulation, or do you see it as something that's highly contentious? And what would be the path forward if it were to become a regulation?
Unfortunately, I think there's no choice here for the DOJ to raise the fee. I mean, if DOJ doesn't raise the fee, looking at the numbers that they've included with their proposal, the system is insolvent, period. And so you'll have a $25 million loan that can't be repaid in a system that is constantly losing money every year. And so that's the ultimate downside here, that if this system were to continue, then the fee simply has to be increased, and there's no other way around that. And so that's why I think it's important that obviously the litigation is hopefully once the Duncan case gets rolling here, that we'll be able to potentially get some sort of injunction or otherwise that prevents this from being enforced pending a resolution of the case.
Well, certainly something we're going to follow along with. Certainly something we're going to be sending out information on so that you can advocate against this raise of this fee. Be sure to follow along with us, guys. We're going to be sending out emails. We might even do another video on it. Matt, thank you very much for coming on and explaining all this. I know you're a busy guy, and I really appreciate you being here.
Happy to be here. Thank you.
Absolutely. And guys, if you want to see more videos like this, you want this kind of information and ways that you can advocate when these things are impressed upon us, please be sure to like, share, and subscribe to these videos. It is a way that you can directly contribute to Second Amendment litigation and legislative efforts here in California. Thanks again, guys, and we'll see you on the next one.